Welcome to the Sound of Ideas from IdeaStream Public Media. I'm Stephanie Haney. Thank you for being with us. Today we're talking about the domestic violence case involving Cleveland and Columbus business owner Bobby George, who is a co-owner of the Town Hall Bar and Restaurant in Ohio City, as well as other establishments. Now, if this topic may be upsetting to you, please proceed with caution throughout our show today. In August of 2024, the city of Cleveland raised allegations against George. Those allegations included charges of attempted murder, rape, strangulation, kidnapping, and felonious assault. More than a year later, on November 3rd, that case was resolved when George pleaded guilty to attempted strangulation of a woman he was dating at the time. The case was handled by a special prosecutor from Jefferson County who was assigned to the case after Cuyahoga County prosecutor Michael O'Malley recused himself. O'Malley recused himself to avoid the appearance of a conflict because he had accepted campaign donations from the George family. Now, the difference between the initial charges presented by the city of Cleveland and the final plea deal George entered into have raised questions and some criticism from the community. So today we'll be talking through what led to this deal. Joining us for this conversation, we have the special prosecutor who handled the case, Jane Hanlon. Jane, welcome to the Sound of Ideas.
Good morning.
We're also joined by plea deal expert, retired judge, and former Ohio Supreme Court Justice Michael Donnelly, who is now an adjunct professor at Cleveland State University School of Law. Judge Donnelly, welcome to the show.
Thank you for having me.
We've also invited George's defense attorneys, Kevin Spellacy and Diane Menashe, to be here today, but they didn't return our requests for interviews. So we're also joined by criminal defense attorney Terry Gilbert. Terry, welcome to the show.
Great to be here.
Now, Terry was not involved with this case, but he has extensive experience from the defendant's side in criminal cases arranging plea deals with prosecutors, so he'll speak from that perspective with us today. Now, if you have questions for any of our guests, you can give us a call. The number to do that is 866-578-0903. You can also email us at soi@ideastream.org, and you can send us a message on Instagram at The Sound of Ideas. Now, Jane, you reviewed the evidence in this case for a year, give or take, depending on when you got the case file, because we know that wasn't instantly. So what can you tell us about what you saw and why it took so long to resolve the case?
I had the opportunity to look through all of the evidence in the case, to work very closely. There was a detective assigned to this case, Detective Emily McKenzie from the Cleveland Police Department. And she and I worked closely together to look at all of the evidence. Some of it was photographic evidence. Some of it, and it takes a while to come back, is digital evidence. If you're talking about evidence from cell phones or computers, that had to be sent away and analyzed. And then once it came back, allow us time to look over all of that. I worked closely with the victim in this case, with the victim's family, and we did that sort of every step in the way. As we were getting information back, we would meet with the victim and her family again, and just continue to review all of the evidence that we had.
Can you tell us anything about the evidence that you saw that was informative for you throughout this case?
Sure. There was extensive interviews with the victim. And in these types of cases, that's where a lot of the information comes from. There was also information from cell phones, information from laptops, recordings of various conversations, and we had the opportunity to review all of that and to review it very closely with her and with the detective.
Okay. I'm going to read portions of the victim impact statement.
Sure.
Now, this was presented to Judge Joy Kennedy, who ultimately handed down the sentence in this case. It wasn't read aloud in court, but it was available for people after that. So I'll read you portions of that now for our audience. It's hard for me to put into words the way this all affected me. I feared the city I once called my home. I have difficulty trusting anyone besides my family. I'm triggered with reminders of the abuse I endured daily. I am terrified of the defendant, his lies and manipulation, and what he may do to me or someone I love in retaliation for speaking out. For my safety, I moved in with my parents. I find it difficult going anywhere alone or anywhere outside my house at all. The defendant had control over almost every aspect of my life. During the relationship, I lived in a bubble controlled by him. He made me quit my job as an employee for him because he believed my mission in life was to care for him. He slowly continued to isolate me and gain control of my life, restricting who I saw or spent time with. He would watch me on the cameras while I worked or was at his places in my free time since I wasn't allowed to go anywhere else. He had a tracker on my car and had me followed by his people during the relationship, when we were broken up, and even when I was out of the state. He didn't want me to be in school as it interfered with being available for him and what he needed. Now, to summarize some of the statement, the victim then describes very violent physical abuse, including pinning her to the ground, shoving a towel down her throat, and she says admitting to kidnap her and threatening her family members. And to continue reading directly from the statement, she goes on to say, "Fast forward to today, my health has been negatively impacted from my time with the defendant. The concussion I sustained from him led to further issues, making my time in school longer and more difficult than necessary. My mental and emotional well-being was negatively impacted as well. I am in therapy to deal with his abuse, along with the extensive emotional and spiritual manipulation." The victim ends by saying, quote, "Your Honor, my hope is that whatever punishment you so choose will hold this man accountable for what he has done. I know it is not a question of will he hurt someone again, but whether a woman will be willing or able to come forward again, This has nothing to do with his name, money, or status. His contributions to the city should not overshadow what he does in his private life and allow him to not be held accountable for the actions he voluntarily chooses to make. Thank you." And that was the end of the victim impact statement. So I'll ask you, Jane, what were your conversations with the victim like?
They were emotional. These cases are very difficult for a number of reasons. And you see this a lot in domestic violence and partner abuse cases where she really did love this man. And there were times when the relationship would be good, but when it was bad, it was awful. And so the conversations with her were very emotional because when you're in the middle of one of those relationships, the bubble that she describes is very real. It's hard to see your way outside of it. And so she wanted him to be held accountable, felt very, very strongly about that she wanted people to know who he was and what he had done. But at the same time, these are exhausting cases and terrifying cases for victims to go through, to relive everything that happened to them, to think about having all of the most intimate details of their life exposed in a courtroom. In a lot of ways, this system is humiliating for victims because of what they have to go through to get justice. And so these conversations were hard. And I give her so much credit, and I know that Detective McKenzie does too, because a lot of victims, I've been a prosecutor for 20-some years, they can't see the process all the way through. At some point, they want to move forward with their lives. They're afraid of being in a courtroom. They're afraid of retaliation. They're afraid of being ridiculed. And she didn't. She really stuck with us every step of the way. And that's a very hard thing to do when the defendant is more than a decade and a half older than her. And the power balance in that relationship was never equal. It was always to his advantage. And so all of our conversations were very emotional. And I could see how much she was struggling with what had happened to her and how to make sense of it and how to be able to best move forward.
Now, Jane, the indictment, which was filed by Information, says that the attempted strangulation charge was related to things that happened on or around June 9th, 2024. Are you able to tell us more specifically what events it were that led to the charge that George ultimately pleaded guilty to?
Yes, that was a particularly bad incident between the two of them, a particularly violent episode. And the accusation was that they were arguing with one another. It turned violent. She wanted to leave. He wouldn't let her leave. And one of the ways that he would control her was he would either put his hands around her neck or shove something down her throat so that she couldn't call for help. So that was a very particular instance that she recalled clearly, and that is the charge that he pleaded guilty to.
Okay, now, Judge Donnelly, this case didn't go to a grand jury to determine the ultimate charge that George faced. So is that different than what typically happens in Cuyahoga County?
Yes. So typically in Cuyahoga County, the vast majority of cases are not presented by way of information as it was in this case. There's two ways in Ohio. They're both legal. In a lot of rural areas, they use an information where the accused waives their right to have the facts presented to the grand jury. But the vast majority of people in Cuyahoga County have their cases presented to a grand jury. As we speak right now, on the third floor of the Justice Center, there is a grand jury meeting, and the prosecutors there, and they are presenting evidence of probable cause, and that's what it's for. It's done in secret in order to protect people, unless in the event that there is no probable cause, from having their names sullied in the media. That's why they do it in secret. And if they find probable cause, then they'll issue an indictment, and then the next step, usually in a felony case, they will appear at their arraignment. 99% of the time they enter a not guilty plea, and a bond is set, and then one of the 34 judges in Cuyahoga County will be assigned to the case. That's the usual route that a case proceeds in Cuyahoga County.
Mm-hmm. And the law does permit for filing the charge by information.
It does.
Okay. Now, Terry, in your experience as a defense attorney, we know in this case that George waived his right to have the charges against him presented to a grand jury. So how common is that for you in your criminal defense practice?
Not very common. But I want to say that as a criminal defense lawyer wearing that hat, the system encourages resolutions mostly in the form of a plea bargain. But this case seems to be a bit odd because, one, the prosecuting attorney for Cuyahoga County had to withdraw. A new prosecutor came in to take a look at it, and as she indicated, Jane, that she did an investigation. I don't know the facts of the case. I don't know the evidence of the case, but I respect, as a lawyer, the idea that both sides got together and came up with a resolution that was also, agreed to by the victim. But on the other hand, I can understand why a number of people in the public were outraged by this. Of course, they just look at this and see 9 very, very high-level felonies like attempted murder, kidnapping, a couple counts of that, felonious assault, rape. These are cases that normally involve very serious sentencing, years of imprisonment. This case started in the Muni court, but it was bound over, but there was never a grand jury, as Judge Donnelly indicated. And so there was at least a year or so that went by where it didn't seem like anything as far as the docket was concerned was happening. And it all came together seemed like a last minute where all these felonies that were first-degree felonies, second-degree felonies, and other charges were dramatically reduced down to an attempted strangulation, whatever that is. I'm not sure how you can perceive something of an attempt at either you strangle or you don't strangle. But so as an attorney, I think the lawyers did a great job. I think the prosecutor and them came up with a decision, and the judge had the right to allow this plea to go forward the way it was recommended.
Thank you for sharing that perspective with us, Terry. I want to get to a couple of calls and emails that we have from our audience members. Tony from Cleveland is calling in. He has a question for Jane. Welcome to the Sound of Ideas, Tony. Go ahead.
Yeah, so I understand that the first prosecutor in the case had to recuse himself from campaign contributions, so it's pretty obviously apparent to someone like me, who has no clue who Bobby George is, that this man is financially and probably has personal connections to the court. And after hearing that victim statement, it was absolutely harrowing, to say the least. And then I saw that the 9 felonies that he was originally charged with were all dropped down to a minor felony in a plea deal, but then he still ended up pleading not guilty to that. So as a man who grew up with a sister, a mother, and a lot of other significant women in his life, I feel obligated to ask, Jane, can you truly say that you believe that this is the same sentence, probation, that the average working class man without connections would receive coming into the courts with the same original charges and the same victim statement? Because to me, that is not believable.
I understand the question, and let me say this. His status had absolutely nothing to do with how this case was resolved. Like the caller, I had absolutely no idea who Bobby George was. I had never heard his name before I was asked to serve as a special prosecutor on this case. I had no idea who he was, no idea who his family was. It played no role whatsoever. What did play a role in the discussions, and it isn't unusual for charges when they come out of the municipal court to be different than what they look like at the end. My vow to the people of Cuyahoga County was that I didn't speak to that prosecutor. The whole reason that I was brought in was to look at this with fresh eyes, without any connections to anybody in Cuyahoga County. So when the case was turned over to me, that's where it stayed, with me, with the detective, with the victim's advocate, and with the victim, so that there was no outside influence at all. One of the things that was really driving this was striking a balance between labeling Mr. George for what he is, which is a man who hurts women, making sure that he was a convicted felon, making sure that it was an offense of violence, and at the same time doing everything that we could to protect the identity of the victim, and to give her space to heal and move forward. So that's what was driving this. Mr. George and who he is or who he isn't had nothing to do with it at all.
I want to remind people that we're talking about the domestic violence case involving Cleveland and Columbus business owner Bobby George. Among the many establishments that Bobby George is involved with includes Town Hall, which is in Ohio City here in Cleveland. And we are talking about how the charges initially started from the city of Cleveland's prosecutor's office, and then the plea deal, which he ended up pleading guilty to attempted strangulation. If you have a comment or a question, you can give us a call at 866-578-0903. You can also send us an email at soi@ideastream.org. I'll read an email that we received now from Chris in Shaker Heights, and Chris says, "This ruling and sentencing was based on nothing more than money, power, influence, and corruption. George got a sweetheart deal because of who he is. Nothing new in Cleveland." Chris, thank you for sharing your perspective there. So, Jane, let's talk about the disparity between the initial complaint that was filed from the Cleveland City Prosecutor's Office and then what ended up resulting. So the initial complaint included charges of attempted murder, rape, kidnapping, strangulation, and felonious assault. And then George ended up pleading guilty to attempted strangulation. So many people are saying this means one of two things happened. Either George was overcharged in August of 2024, or he got a sweetheart deal, which is what our audience member was just suggesting, because of his wealth and influence. So what do you say to that?
I think it's neither of those things. I think that the charges that came out of municipal court in terms of why that prosecutor charged the way she did, she didn't have that case for very long. I sat with this case and with the detective and with the victim and with the evidence for nearly 14 months. And spent much more time with the case, which is not unusual at the muni court level. It's normally just bound over. I don't think that men who treat women this way are necessarily trying to kill them. I think they're trying to control them. And so what we were looking at is what was the motivation for what he was doing to her. And to me, these relationships are oftentimes about control and his desire to control this very young woman in every way possible. And as she said in her statement, these relationships, they have sort of an arc where it starts with yelling. It starts with sort of verbal abuse. It starts with isolating the victim, and then it ramps up to further isolation, to pushing, to shoving, as she described, to hair pulling before it eventually escalates to the charge that we arrived at in the information. And so I don't think, if you ask Mr. George, he believes he got a sweetheart deal. From the comments that I have seen from him, he has been outraged. He continues to act as though he has done nothing wrong. And that is one of the primary reasons that we wanted that label to stick with him, so that the next time he meets a very young girl, whether that's somebody that's working for him or somebody that he meets just in the public, that they know who he really is. Because I firmly believe that who he is behind the scenes does not at all match the public persona that he wants and the opinion that he wants people to have of him.
Now, Judge Donnelly, the judge in this case, Judge Joy Kennedy, said that she might have given George jail time if both the defense and the prosecution, along with the victim, had not agreed on the recommended sentence that he got, which was 5 years of probation. He could have gotten between 6 and 12 years incarceration, also fines, but he ended up with 5 years of probation. Is there anything out of the norm about Judge Kennedy making that call to go along with the recommended sentence and considering the victim's stance on it?
Well, I think there's an inconsistency. You know, in the federal system, judges are not allowed to they're prohibited by rule from getting involved in the plea bargain negotiations between the government and the accused. Those prohibitions don't apply in Ohio, and there's a lot of mystery about plea bargaining, rightly so, because a lot of what gets discussed in the formation of those plea bargains takes place not in open court, but usually in the judge's chambers, where the prosecutor's there, the defense lawyer's there, and the accused isn't there usually, and if there's a victim in the case, they are not there as well. So, from your callers, I can see there's a lot of questions how this resolution arrived at it. A lot of people don't know what it means to attempt to strangulation. Like, what were the facts that it could have been an actual attempt that was not carried out? But as every prosecutor and defense lawyer in Ohio knows, the attempt statute is used as a mechanism to lower the felony that you're charged with by one degree, which lowers your criminal liability. So, the questions, and these occurred before Ms. Hanlon became involved. The defense attorney accused the city prosecutors of overly exaggerating the charges, which means the facts didn't support the charges that came out. When a plea agreement is arrived at in the state of Ohio, the judge has an opportunity to refer the matter for a pre-sentence report. And that's usually done in Cuyahoga County in the probation department. They look at the police reports. They look at the corroboration, medical records. So they have a clear understanding, at least from the government's point of view, what happened. You also get to hear from the defense. Mitigation. Mitigation is usually, I'm sorry for what I did. I'm sorry, but here's some facts that explain why I did, and I won't do it again. And then you also are able to get what's known as an Ohio risk assessment, which is a data-driven tool designed to tell the judge at sentencing, is this person a threat to the community? Are they prone to reoffend? And then that way, if you're going to be put on community control, which is probation, you know how to supervise that person and what they need in order to protect the public from future offenses.
I want to remind our audience that we were talking about the domestic violence case involving Cleveland and Columbus business owner Bobby George. We were just starting to get into the conversation about what typically happens in a pre-sentencing investigation and the role of that, which didn't happen in this case with the ultimate guilty plea of Bobby George to attempted strangulation. We're going to take a quick break, and then we'll be back with our panel right after this. This is The Sound of Ideas. Stay with us. Welcome back to The Sound of Ideas. I'm Stephanie Haney. Today we are talking about the domestic violence case against Cleveland and Columbus business owner Bobby George. We have the special prosecutor who handled the case with us, Jane Hanlon. We also have plea bargaining expert and former Ohio Supreme Court Justice Michael Donnelly, retired judge and now an adjunct professor at Cleveland State University School of Law. And we have Terry Gilbert, who is a prominent criminal defense attorney here in Cuyahoga County. We did invite George's defense team to join us, Kevin Spellacy and Diane Menashe. They did not return our requests for interviews, so we have Terry with us to share their perspective of a criminal defense attorney. If you would like to call in with a comment or a question, that number is 866-578-0903. You can also email us at soi@ideastream.org. Now, before we took a quick break, we were talking about the role of a pre-sentencing investigation, which is something that did not happen in this case. Judge Donnelly was telling us kind of what would have happened if a pre-sentencing investigation had taken place. Now, Terry, I'll ask you, as a criminal defense attorney, do you ever advise your clients to waive their right to a pre-sentencing investigation, as we saw happen here with Bobby George?
It's rare because judges want a pre-sentence investigation. As Justice Donnelly said, it provides the judge with background material, police reports, other aspects of the defendant's life. So this is pretty odd that it doesn't happen. In this case, the judge just simply agreed to the recommended sentence without the pre-sentence report. I find that to be a bit odd because the judge is required to look at all the facts of the case, and the only thing that the judge received was the victim's statement. And another thing about this case, which is concerning of me, I mean, once again, this was a legal deal. It was fine as far as what the representation was for the defense, as well as the input with the prosecutor, and they came up with a deal. But putting my hat on as a criminal justice person who has advocated for reforms in the system for so many years, I find it very, very troubling, because I've had many cases of domestic violence. And it's often the case where the victim backs off because they don't want to go through the trial, or they have different views about what happened, or they didn't want to take the witness stand for some reason. I don't know why that was. But it just seems a valid concern by many people in the community of how this came down. And there is, nationally, in the U.S., statistics that show that people with wealth and power get off easier than a common working person, or that gets in trouble with a spouse or in a relationship. Also, cases involving people of color often result in higher sentences than those who are white. These are facts, okay? I'm not saying that's the case here, but I can understand why people are upset about this. The city of Cleveland, the first event or so was in 2023. Nothing went on until August of 24, when the complaints were filed, the serious offense allegations. And I'm wondering, what kind of investigation did the city of Cleveland police detectives do in this case? Why did it take so long on a so-called domestic violence case for them to file charges? That is a question that should be addressed, not necessarily by Jane, but by the Cleveland Police Department. And adding the idea that there was no grand jury indictment, that another year went by before any resolution took place. I understand why people are upset about it. And I've represented people who are in domestic violence situation where the victim backs out and the courts force that victim to testify, or they could be held in contempt or can be charged with false statements. So if you put this all together, you see a situation where people believe that a guy with power owns a lot of businesses, his father's a big political donor, that had something to do with how this turned out.
We have a call now from Frank in Cleveland. Frank, welcome to the Sound of Ideas. Go ahead.
Hello.
Hi, Frank.
Hello?
Welcome to the Sound of Ideas. Go ahead.
Yeah. Number one is what time period did he know this lady? Was it many years? Was it 5 years? Was it 6 months? And also speaking about evidence and facts, was she injured? Was she hospitalized? Did she have many bruises? Along those lines, and Mr. Gilbert is definitely right. If you have a high-powered, connected law firm, you get a much lighter sentence, obviously, because they know the ins and outs and all the little tricks that can be played. Thank you, and I'll wait for your answer.
Thank you, Frank. Jane, can you speak to the relationship that the victim had with Mr. George?
The relationship spanned close to a 2-year period. And that's part of the difficulty in these cases, because it isn't unusual at all. And I think Terry will agree with me, in domestic violence cases where people in these relationships, they're together, they're apart, they're together, they're apart. The victim hopes that it's going to get better and returns to the relationship. So it makes things like establishing dates very difficult when you get to the charging phase, when you're talking about a relationship that's gone on for a couple of years, because there were times that they were together, there were times that they were apart. I think that as many of the questions, and I think they're valid, but I think the people in Cuyahoga County can be proud of a number of things. Despite Mr. George's wealth, and notoriety here, when this case came to Prosecutor Mike O'Malley, he immediately took a look at it, did not want people to think that something was going to happen because of Mr. George's influence or power, and he immediately recused himself and sought out a prosecutor who did not know the Georges, who had no connections to Cuyahoga County or Franklin County, where he owns businesses at all. And so I think the people of Cuyahoga County can be proud of their prosecutor, that this was not something that was done in secret by the people in the know. What he did was, as soon as he realized that Mr. George's father had donated to his campaign, he immediately recused himself from the case. And from the moment he did that, nobody in Cuyahoga County, other than the detective and the victim's advocate, had any role in this case whatsoever. And so I think the folks here can be proud of that. In terms of the injuries sustained by the victim, the caller's other question, yes, there were times during the relationship that she had various injuries. What is also not uncommon in relationships like this is a failure to get treatment because they're afraid to tell somebody what happened to them, or what's going on in their relationship. And so if you talk to survivors of domestic violence, they will do almost anything to avoid having to discuss what's happening to them. And that includes sometimes not going for the treatment that they need or that they should get, because they're afraid of the consequences. They're afraid of their abusers finding out that they went for help. And that's not unusual in these cases at all. It makes them very difficult. And one of the other things I know that we have talked about is that these cases are different because the victims are still alive. And so when I'm prosecuting cases where the victim has died, you don't have that burden of worrying, excuse me, what additional damage are you doing to the victim? Are you re-victimizing them? Because the worst thing has already happened. That isn't true in these domestic violence, physical abuse, partner abuse cases. She's still very much alive. She resides in this community. She has to go about her life and with her friends and her family and think about everything that she's ever said or done in a relationship being exposed. And that's extraordinarily difficult to ask a young woman to do. And it is, Terry's right, the reason that so many people can't see it through is that they just get to a point where it feels like more and more abuse, and they just want the ability to move forward. And that was our hope for her too, was to hold him accountable and then give her the freedom to move forward with her life.
We have an email from Daryl in Euclid, and Daryl asks, from a layperson's perspective, attempted strangulation sounds like attempted murder. Is there a legal definition that differs from that interpretation? Jane, I'll ask you.
Yeah, the attempt statute just says it adds a line to the charge saying that he did attempt to cause physical harm to her by means of suffocation or strangulation. And so that is the strangulation statute in Ohio is relatively new. It's within the past couple of years, and Ohio was one of the last states in the country to have a strangulation charge. So in some ways, it's not as tested as the other criminal charges that have been around forever. Strangulation is a relatively new charge, and it came about precisely because of cases like this. There were cases that were being prosecuted where the state was having a hard time proving the element of serious physical harm in a felonious assault case, because oftentimes people who choke their victims or strangle their victims, it may not leave any marks. If they don't lose consciousness, when the pressure is relieved, you may not see marks, you may not see injuries. And so when prosecutors were attempting to prosecute those cases as felonious assault cases, oftentimes they weren't able to get convictions because it doesn't necessarily look like what people think it's going to look like. You can suffer immense pain and terrifying fear that you can't breathe, and when the abuser removes his hands, there may not be marks. And so that was the whole reason for enacting the strangulation statute in Ohio, was to give prosecutors and police a way to hold people accountable who do that particular act to their victims.
So is that the point with the strangulation charge, the attempted strangulation charge, is that strangulation, it's different than attempted murder because it doesn't always result in death. There are lots of varying degrees of
Correct.
injury.
Right. It doesn't always result, it always results in fear. If you've ever had the feeling where you can't breathe and someone who is much bigger than you, much stronger than you, is on top of you, it's terrifying. It can cause serious physical harm. It can cause moderate amounts of harm. Sometimes it doesn't cause any long-term harm. But it's hard to know that in each case. And it's very hard in these domestic violence cases because it happens in the continuum of a relationship that then goes on after that. And so it's not unusual at all for victims not to seek medical care after being strangled, either because of fear or because there may not be at that moment injuries that you can see or injuries that require immediate treatment.
Let's go back to the grand jury piece of this conversation. It's something that we've visited in different moments at different parts of this conversation. Now, Jane, you said several months ago that the case would go to a grand jury, but the final charge was by information, so you filed that. So why didn't you take the charges to a grand jury?
We were actually scheduled to appear at the grand jury. We had that set. We were absolutely prepared to go to the grand jury. There had been negotiations going on between the state and Mr. George's defense lawyers, and we just simply reached the agreement prior to the time the case was taken to the grand jury. And during that entire process, I would be in contact with Detective McKenzie and with the victim and say, these are where the negotiations are right now. How are you feeling about this? Are we in favor of resolving the case in this manner? And so that's what was going on behind the scenes. And so I understand sort of the public's perception, or if somebody wasn't on the case wondering what's going on during this year and a half. A lot of it is negotiations. A lot of it is review of the evidence and waiting for the evidence to come back. There was not that long of a delay. So from the time that the victim came to the police department and reported what was going on with her, the charges in municipal court were actually filed within a day or so. And then when it was bound over to the Cuyahoga County Prosecutor's Office, that's when Mr. O'Malley recused himself and sent it to me. And so there was no delay in the police investigation at all. I can tell you that from the moment that this hit this detective's desk, and it's the other thing I would want to say about this case, is that Cleveland should be proud of their police officers and proud of this particular police officer, because while I didn't know anything about Mr. George or his family or his influence, the police officer did, and it would have been very easy for her to try to resolve this case as a misdemeanor or just try to get it off of her desk to not have to deal with the intense pressure that came with this case, and she didn't. She's a very young detective, but she was on this case every day, reviewing the evidence, working with the victim, working with the victim's advocate, and I think that the people of Cleveland should be proud of their police officers.
Now, Jane, you had mentioned that if there was no plea deal in this case, that the case would have then gone to that grand jury. Yes. Would it have been the same charge, or would it have been different charges?
It may have been different charges coming out of the grand jury. We would have talked to the grand jurors about the various pieces of evidence that we had and sort of the nature of the relationship over the year and a half to 2 years that they were in a relationship. They may have looked different. And I think that Mr. George waived his right to have the case presented to the grand jury because whether he will publicly say it or not, he knows he's guilty.
Judge Donnelly, I want to ask you about the sentencing in this case. After George's arraignment on the attempted strangulation charge, and at that point he pled not guilty, which we understand is part of the process. There was the hearing later on November 3rd where he pled guilty, and then we saw the sentencing there. But between that time, when he was leaving court on October 30th, there was a video of him saying that the case doesn't affect him, doesn't affect his business at all. Now, if Judge Kennedy had seen that, is that something that she could have taken into account when sentencing him on November 3rd?
Well, if she were going to consider that, it would be important for her to put that on the record, that that's something, and have Mr. George be allowed to respond to that. As many people know, I've identified what I believe are the major flaws in Ohio's sentencing scheme. And number one is, with regards to plea bargains, 97% of all cases don't go to trial. They result in negotiated plea bargains. And judges are able to accept plea bargains or reject plea bargains. And there's really not any objective criteria guiding their discretion on which ones they should do. And there's 400 common pleas judges statewide, and each of them exercise their discretion in different ways. Some judges accept agreed sentences. Some when I was on the bench, I viewed myself as a neutral. So if I thought the parties were acting in good faith on behalf of the clients, and the state doesn't represent the victim, the state represents all of us. But they have to take the victim into consideration, obviously, as Ms. Hanlon has pointed out. If I thought that was a good faith negotiation and they presented me with an agreed sentence, I usually always accept that. I put it in the judgment entry. The parties agreed. But there are some judges throughout the state that will not accept what they call agreed sentences. They call them agreed recommended sentences, which for the defense is not really a good deal because they are bargaining for some degree of leniency when they negotiate a plea agreement. And in an agreed sentence, agreed recommended sentence, what the judge is telling the defendant is, I'll accept your recommendation, I'll listen to it, but I don't have to follow it. And I can even go more severe. And I think that's a major flaw. And the other major flaw is that we don't have data. Judges under Ohio Revised Code 292911 are charged with punishing people that commit similarly situated crimes with similar sentences, regardless of the color of their skin or their socioeconomic place in society. And in order to do that, you have to have data so that you can compare apples with apples and treat people with similar sentences. And we have the data in the federal system, and Ohio is way behind all other states in having no sentencing data that you can show to a judge and say, Judge, this is what you've done in similar cases, and this is how this person should be punished.
I'm going to read an email now from Marika that has come in. Marika says, if people listening do not approve of Bobby George's conduct, the most powerful way to express this is through the wallet. Stop patronizing Barley House, Rebel, Forward, and Town Hall. And I will just note some of those establishments mentioned are owned by the George family, not necessarily directly by Bobby George. Marika, thank you very much for sharing the perspective with us here on The Sound of Ideas. We are talking about the domestic violence case against Cleveland and Columbus business owner Bobby George. He pleaded guilty to attempted strangulation on November 3rd. And we're talking about the resolution of that case. If you have a comment or a question, you can call us at 866-578-0903. You can also send us an email at soi@ideastream.org. Now, a lot of people do have questions, Jane, about what was happening behind the scenes. You know, as you had mentioned, there was quite a bit of time where you were reviewing the evidence, looking into this. The hearing on November 3rd, where we saw Bobby George plead guilty to attempted strangulation and then ultimately be sentenced to 5 years of probation, it was supposed to start at 2 p.m. Mm-hmm. It didn't start until shortly after 3 p.m. So what was happening during that hour or so?
We did. We met with with Judge Kennedy. We had the opportunity to meet with the judge, defense counsel, and me. And we wanted, as Judge Donnelly was saying, to give the judge an idea of what had been going on because she had just been assigned to the case, and so she didn't know much about it. Because there wasn't a pre-sentence investigation in this time, and a lot of the times those focus on what are the defendants, what's his criminal history. And in this case, Mr. George didn't have a criminal history, so that wasn't information that we needed to wait for. We knew that he didn't have prior criminal convictions. So part of it was bringing her up to speed on where we were with the negotiations. Part of it was determining what we were going to do with the victim impact statement and how it would be presented to the court and how it would be maintained by the court. I had another round of conversations with the victim before we went into the courtroom. And so those were the things that were going on behind the scenes before we actually walked into court, and he pleaded guilty.
Okay. Now, Judge Donnelly, as a plea bargaining expert, is anything the prosecutor just described there out of the norm?
Well, when I was on the court, I did things a little different. I came to the conclusion that no one should ever say anything in the back room that you wouldn't repeat verbatim. So, and like I said, in the federal system, judges are prohibited from being involved in the plea bargaining process. So when I was on the court, I did everything on the record. And that way, any representation that is being made by the prosecutor, by the defense counsel, and myself as the judge, we're held accountable. So if I make a representation to the defendant after listening to the advocates that he or she is going to receive some type of negotiated outcome, and I say I will go along with that as an agreed sentence, then I don't get to change my mind 30 days down the road, or if I'm in a bad mood, or if I forget that. So if judges are, my position, my opinion is if judges are going to get involved in the plea bargaining process, they should do it on the record, because I have not heard an argument yet. Terry, if you can offer one, why, what would be the purpose of doing discussions, especially with the neutral, the judge, off the record?
And that actually brings me to my next question for Terry as well. Terry, please respond to that if you have a response to it. And I just would like to ask you, when you negotiate a plea bargain, when you're wearing your criminal defense attorney hat, how often that happens in open court versus in closed chambers?
Well, it happens in chambers a lot, okay? And I understand Justice Donnelly and I have talked about these dark pleas that are not transparent, et cetera, and I understand that. But when you have a client who can negotiate a case without being public and exchanging ideas and positions about the case and doing it in a private setting with the judge, I understand why people would think that's backdoor dealing with criminal cases. So, but in this case, it's not just that there were discussions with the judge. It was that the judge didn't force a pre-sentence investigation. It's more than just criminal history. It's about the facts of the case, the evidence, how the community may respond, balancing the principles of sentencing with rehabilitation, and all these things should be presented to the judge before she made a decision. And this happened just so quickly. First of all, it was like over a year after the original complaint, and when the information was filed, it was like 14 months, I think. And so what was going on all this time, and why was it done so quickly? These are questions that I wouldn't even ask you because they're probably privileged information, but still, we're talking about how the community reacts to this whole thing. We're still at a point where people have questions and wonder really what happened in this case.
I'll share an email now from Jeffrey. Jeffrey writes in, as someone who has worked in the system for 20 years, I can say that most cases in Cuyahoga County are overcharged at the beginning. It's extremely typical for the charges to get reduced to a more reasonable charge to get a plea. To those of us working in the system, this is very normal. For those in the general public, it looks like a sweetheart deal is being given. I don't know the details of this case, but I can tell you that it's not unusual for cases to be overcharged and then reduced for pleas. And I'll share, since he says he works in the system, and attorney, it's Jeffrey Black, Esquire. Jeffrey, thank you so much for sharing your perspective with us here on The Sound of Ideas. We have an email in as well from Marvin. Marvin writes, anytime there is an imbalance between the wealth of a victim and a perpetrator, there is an unfair incentive for a victim to accept a settlement or be okay with a plea deal. No matter how much you try to not let wealth or power influence an outcome, you can't eliminate it. Marvin, thank you for sharing your perspective with us. Jane, do you have a response to that perspective?
And I agree that, so I think the purposes of felony sentencing under the code are to protect the public and to punish the offender. But there's a third branch of this now that we have to take into consideration, which is the protection of the victim. And their input into the resolution of a case is crucial at this point. And so I think we were able to achieve that in this case, to punish him, to protect the public by letting them know who he is, and then to protect the victim and allow her to move forward with her life as well. And so I think that we struck that balance of all three in this case.
I want to thank our panel members for being a part of this conversation today. We have Special Prosecutor Jane Hanlon, who was assigned to the Bobby George domestic violence case. Jane, thanks for being with us.
Thank you for having me.
We also have Terry Gilbert, criminal defense attorney here in Cuyahoga County, among other things. Terry, thanks for being here.
Thank you.
And Judge Donnelly, retired judge and former Ohio Supreme Court justice and plea bargaining expert, also adjunct law professor at Cleveland State University. Thanks for being with us.
Thank you. It was an honor.
I would like to let people know, if you or someone that you know is in need of support, the National Domestic Violence Hotline can be reached by phone at 1-800-799-SAFE. You can also text START to 88788, and you can find it online at thehotline.org. To get the last word on today's topics, you can send us an email at soi@ideastream.org. Yesterday, we talked about the impact of rising health insurance premiums in the Affordable Care Act marketplace and also for employer-covered health plans. Logan from Akron emailed, "You just don't turn off a major public assistance program like the Affordable Care Act without having a place in Plan B in place. Without such a Plan B, I predict it will not be long before emergency rooms become inundated sufficiently as to run healthcare costs even higher." Logan, thank you very much for sharing your perspective with us here on The Sound of Ideas. Tomorrow, we'll be looking at the concept of phubbing, which is snubbing the people that we love for our phones. We'll look at what constant screen time means for our minds, our moods, and our most important relationships. And we'll also have The Shuffle with Amanda Rabinowitz with her guest, Lakewood singer-songwriter Bethany Joy. If you missed any part of today's show, you can listen to the Sound of Ideas podcast or watch the show on the IdeaStream Public Media YouTube page. You can also hear a rebroadcast tonight at 9 on 89.7 WKSU. I'm Stephanie Haney. Thank you for keeping the conversation going. We'll see you tomorrow.